As I said, my name is Judy Herman. You have my address already. I've got long ties to this district. My family's lived in West Bloomfield since 1978. I've been a tax-paying homeowner since 1989. As I said, I have two daughters, one in the 6th grade and one in the 9th grade, and been heavily involved in my schools and in the district, and know most of you sitting up here, and have worked with you on many things. There's an issue that's of great dismay to me, and I started when I was, we were sidetracked. I was saying the district, especially in these economic times, must be ran with responsibility, with reflection, with transparency by individuals who will put our children first, to be educated to be the best in and for the world. That's our school district's mission. Unfortunately, the VSIs that were given to the administrators and the executives earlier this year defy that mission. In my mind, they're a catastrophe. And like most catastrophes, this catastrophe arose out of a combination of events, any one of which, if handled differently, could have avoided this huge $500,000 financial burden to our district and our children. And I also want to say that due to the time period over which these events took place, each member of this board, old and new, bears some responsibility for this burden. And I would like to highlight for this group in the community the main events that they should be aware of. I'm not going to highlight all of them because I'd be here for a very long time. But event number one is that in 2008, this board entered into its collective bargaining agreement with the administrators. That agreement was intended to include the same VSI offered to the teachers. However, the contract didn't include a detailed VSI. Instead, it simply said voluntary severance incentive, capital V, capital S, capital I, $70,000. This board, or the board then, completely failed to ensure that the precise terms of that VSI were documented. The board apparently relied on the administrator who negotiated the contract and later took the VSI himself to draft that contract. No outside legal counsel reviewed that contract. And in deference to the gentleman who spoke before, I will say in that case, outside legal counsel, and frankly any businessman and anybody with any acumen whatsoever should have realized that there was a document that that was related to. But it is not included. And as a matter of background, for those of you who don't know me, I am both an attorney and a certified educator. So this really upsets me. But it's those failures that led this board to extend the VSI to the administrators and the executive employees who left the district last year without regard to eligibility requirements or deadlines. If someone, anyone, had carefully reviewed that agreement, we could have avoided this $500,000 financial burden, $560,000. Now, but you know what? That was the first time. The second time we had an opportunity to avoid that burden was last year when our human resources administrator opted to take the VSI, which was conveniently added to his contract. At the May school board meeting, board member Melanie Torbert publicly objected to this late election of the VSI. She noted on the record at that board meeting that there was an election deadline that should have applied, October of 2008, just like the deadline was applied to the teachers. If this board had acted then, evaluated the true intent underlying the administrator VSIs, utilized people other than those directly benefiting under the vague contract language to evaluate this issue, it may have avoided opening the floodgates. But it did not, and the result is the floodgates were opened. Now, event number 3 is really a cascade of events. This summer, I personally reached out to the board and the superintendent and strongly urged the board to revisit its strict interpretation of this vague contract language. I urged the board to do this before the board entered into additional contracts with the exiting administrators and executives, both retiring and not. Instead of acting in an objective manner and in the district's interest, the board majority essentially stood in the shoes of the administrators and the executives who sought the VSI and took every action possible to validate those contracts. How did they do that? They entered into the contracts, notwithstanding these objections. They paid the money, the first payments, notwithstanding these objections. And most egregious of all, in my personal opinion, is that instead of hiring independent counsel to analyze its obligations, the board paid the same attorney to now issue a written opinion regarding the validity of his own first opinion that created the rationalization for these payments in the first place. What's the result? The result is 8 VSIs, at least 3 to individuals who were not eligible to retire, to the tune of $560,000. My initial hope that the board would seek a determination as to the VSI's validity and terms from a court is long gone. I wanted them to do this before its actions buried our district further, but it did not. The superintendent has made public comments, I believe at the last PCN meeting, regretting these VSIs and admitting that there were mistakes made. The board and the administration's party line is that further discussion on this matter is, quote, bad for the district, and we need to, quote, move on. Unfortunately, these acts of contrition are nice, but they are not enough under the circumstances. We, as parents, as teachers, as members of this community, cannot move on. You have exposed our district to greater contention in the current contract negotiations through this action. Educators are losing sight of the economic realities of this time and focusing on this VSI issue. You have harmed our district, not just to great expense, but also to our reputation that goes back to Seymour Gretschko, who always put our children first and always put the money into the classroom first. So I implore you to reconsider, to reflect, and to reevaluate. If you have obligated this school district to pay this taxpayer money, and if there is even a possibility that these obligations were unnecessary and have jeopardized the district's finances and reputation, at a minimum, you must thoroughly reevaluate these issues and even consider truly independent counsel or an independent audit. If this analysis reviews that any one of you participated in any actions or omissions that have cost this district dearly, resignations are in order.